Good evening, everyone, and thank you very much for coming along to TCube. And Eamon Ryan is my name, leader of the Green Party in Ireland. I'm very glad and honoured to be introducing Jan-Philipp Albrecht, a Green colleague from the European Parliament, from the German Greens and European Green Group in the European Parliament. We have a very strong connection with our European allies across the continent, and a particularly strong connection with the German Green Party, who for the years we've had very toing and froing. I'm off to Berlin next week, actually, to the launch of their campaign, which I'm looking forward to. We're particularly pleased to have Jan-Philipp here because, from our perspective, he has been one of the leading parliamentarians in the last 5 years and has shown an amazing example in the way in acting as rapporteur for the data protection legislation that has gone through the Parliament, at how parliamentary democracy can work, how actually an individual can pull people of different political groupings together and pass and support in overwhelming majority in the Parliament necessary, important, progressive legislation. So I think for anyone with an interest in this issue of digital rights and how we regulate and get right the development of the internet, this person is one of the best people you can possibly meet, listen to, and I think not just listen to this evening. There really is an opportunity is to get into a conversation, a dialogue, and to hear what people here have to say. So I won't say anything more. I might come back in at the end with just a few thoughts if I can, but leave it to Jan-Philipp and then to ourselves to have that slightly wider conversation. And indeed, as I said, very glad that we're streaming it live on the internet, opening it up for as many people as possible to kind of make their input or to listen what Jan-Philipp has to say. Jan-Philipp.
Thank you. Thank you, Eamon, and hello to everybody. First of all, let me say thank you to this place, TCube, and Eamon to organize this, and I'm very happy to be here with you, especially because I'm so happy to support anyone in Europe who deals with technology and digital rights. I think it's so important that we get this high on the political agenda with good candidates, with good politicians, but especially also with strong civil society and strong awareness for these problems. Because there are some challenges out there, and when I was elected to the European Parliament in 2009, I came to a parliament which I realized was not very knowledgeable about the actual challenges on the table, but was able to learn and was willing to learn. And now, after 5 years in the European Parliament and with all these colleagues trying to learn about the challenges of today and the opportunities we had to get into regulatory approaches, I think that the European Parliament is the most advanced parliament on these issues and is really knowledgeable. But that we also realize we cannot do the things alone. We need to get the people with us, and we need to get the governments with us, and that's still a challenge. And one issue which I was working on very intensively since some years now, since 2011, 2012, is the data protection reform. So the data protection regulation, which is proposed by the European Commission in 2012 and which we called on as the European Parliament in 2011, so to create a European single standard for privacy and data protection rules, so that there's not anymore the situation of having 28 different jurisdictions, 28 different legal cultures and legal interpretations, which at the end meant to the individual, in most cases, not really a single jurisdiction protecting my rights, and not really a single legal framework being really legally certain for any of the people, not only the individuals, the consumers, the citizens, but also for companies and authorities. And that brought us to the point that we as also those parliamentarians who were in favor of creating European digital rights thought that this might be an opportunity to start off something on positively safeguarding standards for the European or even better international environment in which we are with the digitalization, but of course also with the global environment, the globalization, which is the bigger framework to all of this. I mean, we see that our lives are changing dramatically in a world in which we consume products from all around the world, where we use services which we sometimes don't even know where they are situated. So we even don't know which legal framework applies to most of these services. And in an environment where technology and information systems don't really show the way how things work, how we communicate, where information goes, so that we need to create solutions and rules for these environments to build transparency, to build legal certainty, and to better enforce especially fundamental rights. And throughout the last 3 years I was doing that, I realized that quite a lot of things happened without I was really awaiting that to happen. When I started being rapporteur for the data protection regulation, and so that's the lead negotiator position in the European Parliament, I thought we were somehow talking about an issue which I'm very much interested in and some geeks are interested in, but which is seen to be very technical and very and seen as having a very low political relevance. After at least 2.5 years of debates and negotiations on that, and after the European Parliament has now voted on that law, I can say that this has dramatically changed. It's not at all, and that's after 2-3 years, not at all anymore a technical issue. It's not at all only debated in some environments like this, but it's an issue which is in the heads of everybody out there and which concerns everybody. I have seen hundreds, if not saying up to 1,000 different people and companies and interest groups coming to me who wanted to talk about these issues, people who I thought would be completely uninterested in this issue, or companies who never really had a concern in that, which thought that data protection and digital rights and the whole question of how we regulate the internet environment becomes necessarily important. And that's a huge change. And of course, the last year was making this change of development and awareness visible to everybody because of the revelations of Edward Snowden and all the debates which were triggered with that. I think that now really everybody realized that there is much behind it which is not technical but even bigger than just law. It's constitution, it's value, it's the question of how do we want to live as society. If there's Google Glass out there, how do we want to live as society if there are algorithms which nobody understands, so even no legislator or judge is able to assess what's happening inside this black box, which might be a trade secret in addition. And so all of that became far more bigger, and I can just say that perhaps what we envisage now with the data protection reform on the European level, so especially the regulation, is some kind of avant-garde experiment and debate for quite a huge range of regulatory necessities which we have in front of us on net neutrality, on on the whole intellectual property issues, but I think that it goes even further. We need to talk about, for example, I don't know, tax laws or even social security issues with regard to the information society, with regard to the change which the digital environment and the international community which this involves is bringing up to. Also seeing that we are Europeans having common values, but still, as I say all the time, not really common laws, so we need them. But that's only the first step. We need to look into a global community which still, and that's important to realize that, has no majority of rule of law-based democracies sharing our values. If we want to do really enforceable treaties, for example, some people after the Snowden revelations very quickly called for international agreements, and I was just answering, okay, we already have them, but they are not in force. It would be very, very short-sighted to just think that this is a solution. But even more important is the issue of finding European rules, at least, and taking leverages and timely reactions to set European standards in a global market, which, if we don't find these standards in a recent foreseeable future, in a foreseeable future, then I think these standards, also of fundamental rights, might be set by other markets in the world, for example, Trans-Pacific agreements, or even only Indian or Chinese regulatory frameworks taking over the standard setter. And that doesn't need to be automatically bad, but it's bad in the in terms of our ability to have an impact on that, and our ability to have a legitimate sovereign decision on our way how we want to live together. So that's why I'm there, and that's why I very much like to debate that. And as I said, I thank Eamon very much to take me on board my topic, which you also share, and I thank all the people who came and would like to answer all the questions and get to questions and answers with you directly. Thank you very much.
I might just chair it, if you want. Or,
yeah, of course.
If people want to, as I said, broaden it out, I know there's people in the room here who have very real experience and influence, and huge influence in some of the recent court decisions. I think that's one of the things you've been talking about earlier, Jan, that the decisions by European Court of Justice earlier on having a huge influence. I don't know if we want to start with that, or because some people here have had, as I said, a huge effect in that regard. We could throw it out for maybe questions or comments we could take from there. Sorry. Oh yes, if I could ask anyone to identify who they are, and I might repeat the question as best I can, just so the people online can are aware of the feedback.
Okay, I'm Oisin Smith, and I'm spokesperson on communications for the Green Party. So my question is that the data retention directive has been shot down recently, and what I'd like to know is what are the implications of that, the legal practical implications? Does that mean that it's completely annulled, it's completely invalid? Does that mean that all the laws that have been passed in the member states are now invalid? And does that mean, for example, that tomorrow I could set up an internet service provider with no logs that could take anonymous customers and not provide any information to the police if requested?
Very important question, and I would like to first of all highlight that I think this court case from I think it's 2 weeks ago now is a landmark in fundamental rights jurisdiction, not only in Europe but internationally. It's a landmark in developing a European constitutional fundamental rights framework, and therefore I'd like to thank all those who had the persistence to follow up until the end to get this to the European Court, because it was time it was late enough that we got such an interpretation also of the Fundamental Rights Charter and the fundamental right to data protection, which is in effect a constitutional principle in Europe. And the court has set very significant, for me in parts, even surprisingly clear framework for data protection as a fundamental right, as self-determination, which means that at the end it's clear that there needs always to be a reason or a legitimization, a consent somewhere by society or by the individual to allow data processing, to allow an infringement to our privacy, to our fundamental right to self-determination. It should be the citizens in control of their data, and it should be only in an exception also to government access to this data or even to retention to this data by private companies. I think there are two questions now in the air, and these are very important. The first is, what does the court case mean for the issue of data retention as such, especially for the directive? And there the court was very clear. It was even going further than the general advocate, saying we take the directive down from the beginning. It was always infringing the fundamental right on data protection of EU citizens, because it was retaining blanketly data of all citizens. And I think there the court said very clearly, and that's not okay, because there should be at least intermediary, a link to a crime. If processing of personal data is taking place by law enforcement authorities, so there should be a reason, there should be a suspicion or a risk somewhere in the air where there is data processing taking place by the state. And blanketly retaining everything from everybody is not in line with that, and that means for me that data retention, blanket data retention as it was built in the directive, is dead in Europe, because the court says clearly that's not the way how we see proportionate law enforcement is taking place. The second question, also very important, is what does it mean for national legal environments? So what does it mean, for example, for the 2011 data retention law in Ireland? And there I think, first of all, it would be very awkward if we say, yeah, I mean, the Fundamental Rights Charter says it's unproportionate, but still we think in Ireland it's proportionate to do that. I don't think that would fit into a legal community like the European Union. And the second is that also there is, for example, the European directive on e-privacy, where I would say perhaps it would be even very complicated to justify the retention law in front of that with regard to European laws. And I would say that if we would see now the High Court decision here, the High Court would be very in a difficult situation if it just judges differently now on national laws than the court in Luxembourg judges. I think also that would be very difficult. So at the end I see that data retention, it was a discourse, it was an X-course, but I think we all learned that it perhaps was a wrong X-course. It was not in line with our constitutional principles, and we should finish it. And I think we don't finish effective law enforcement with it. Perhaps it's even the other way around, because for the last 5 to 10 years the focus was on let's retain all the data for the purpose of law enforcement because we need that data, instead of on let's use the data to do effective law enforcement. Because there is much information out there which you could retain on a suspicion, on a risk-based approach, which could give you the opportunity to get effective investigation, but we didn't really work on better investigation, for example, in the internet environment, to get really police officers educated and equipped to use the means they have today based on a rule of law based approach. And I think perhaps this judgment gives us the opportunity to do exactly that, and get effective law enforcement, which also has an effect on crime rates, which obviously data retention did not have throughout the last years. It was a bit longer than I intended to have, so next answers could be a bit shorter.
No. I'll pass the microphone to you, actually, if I can. You might introduce yourself.
Thank you very much. That was very interesting, Jan Albrecht. My name is Cleona Kimber. I'm a barrister and I work in some of this area. I suppose I'm interested to know whether, as a rapporteur, you see much tension between, in the area of not what's retained, but what's actually on the internet, between perhaps US approaches, which are freedom of expression, everything should be put up, and perhaps what I would perceive to be developing EU approaches, which are, well, things sometimes do have to be taken down. I don't know if you've seen much sort of tensions between a European and a US approach, particularly, I suppose, bearing in mind a lot of the big companies, big powerful companies are in the US and maybe have the power to influence regulation.
I would say that generally I don't see that split transatlantically, because if I go to the US and talk to quite a lot of lawmakers and citizens there, they constantly have the same debates and the same concerns like Europeans are talking about all the time, just that they are coming from different legal cultures, which is naturally, and that they have different circumstances. And I would say that's the difference we have. The circumstances in the US at the moment are, and we get letters from consumer and civil rights groups lining out that from the US and Canada, there's no real opportunity for legislative changes in their framework at the moment. And there's, I think, also perhaps a move by political leaders and interest groups into a direction which is not really sustainable, which is not really looking into the future, just on a very short-term vision. And perhaps since decades, for the first time, in that moment, Europe has a responsibility towards the US. That's my impression after all the visits. My impression is that there is the same concerns taking place, and they also have the same problems on the table, but they don't have the solutions and the abilities at the moment to get these solutions done. So it needs some pressure from the European Union to get this moved again and get them realizing that it's about a transatlantic standard which we need to defend some values in a global market. That's how I see it, at least, and my impression is that a huge majority in Europe wants to walk ahead, not seeing data protection, for example, and privacy as being in opposition to business opportunities, but in fact quite the opposite, as seeing it as a precondition for building trust in that transatlantic and global market which we want to build in this digital community. And therefore we need a strong European market setting a standard. Setting a standard now, first of all, for the European market, that's already a challenge to get all the European regulatory approaches together, but also then from there on to a transatlantic and global dimension. And my impression is that more and more companies, for example, in Europe, are willing to walk ahead with that approach, and also because they see it has been, as I said, perhaps the wrong direction to just see everything which is somehow regulatory in favor of consumers, in favor of citizens, or in favor of protection of fair market, for example, as a competitive disadvantage. I think that this was a mistake and that people will learn. And also in the US, I see already some of these big companies turning their face towards saying it's not a disadvantage, it's actually an advantage to walk ahead with quality products and services and create a market which people really can trust in. That's the first step, to give control to consumers, to citizens, over their data. It's not about forbidding using information, for example. It's not about saying that freedom of expression is always in opposition to data protection. We lived with that since 20 years. It's working. It's not that it's completely arbitrary. Courts are reconciling these different fundamental rights with each other. But it's about saying that there should be basic standards like traffic rules out there where people can trust in, and not only somehow the Wild West where people are always in a weak situation towards state authorities or market players and never really in the position to enforce their individual rights. That should not be the case, and I think that Europe is playing a very responsible position in that. So my view, it's very optimistic that we managed to take that responsibility, but it's up to the member states in Europe and their governments to take up that challenge. And there I see some people having less courage at the moment, and hopefully citizens will convince them.
Okay. Lady at the back there, if you want to, I'll come around.
Hi, Anne. Welcome to Dublin. My name's Rachel. I work on Eamon's communications team for the Green Party. Matthias or Mark Döpfner, I think is his name, the German media tycoon with Die Welt and Bild. You know who I'm talking about. You probably know the open letter that he published about a week ago as well, criticising Google. I just like your views on that. I happen to agree with him 100%, but then I'm paranoid, probably. Has he got a good point, or what's your view?
I think he has a point, although it's a bit, perhaps not completely honest, his approach, because he is a very powerful representative of a very powerful German publisher, the Axel Springer AG, which is, of course, in charge of playing this power on the market very easily.
Could you just explain the letter, because I wasn't aware of it myself.
I will explain. So this publisher, this leading manager of the publisher Axel Springer, he sent an open letter to Eric Schmidt, which was published in some German bigger newspapers. I don't know if it was also further spread in English. So he was criticizing Eric Schmidt and Google in a way that he said Google is oppressing the possibilities for companies to not follow their example or to call for more regulation and so on, because Google just has a market power which is for them, making them fear, you know. So and that he says Google plays the card of deregulation and not any regulation, and therefore building a market which somehow makes it impossible for those who want to make a difference to survive. And I think, of course, as I also line out this problematic situation with lack of regulation on a global level, for example, I see a point in it, although I think that, for example, coming from him, it's a bit dishonest because he has the power to impact, and on the other side, he has a very strong interest he has a strong interest as a competitor to Google also, because Google, of course, is endangering the publisher's situation, for example, by using their content in searches, for example, without remunerating them. So they have an ambivalent interaction, more or less. Relationship, that was the word I was searching for. But the content of the debate, which is behind it, is the question, how do we deal in a society, with a society which obviously has so much weaker possibilities to regulate than a a company like Google, which obviously acquires so much information on all of us and acquires so much market power with that on a global market, that it's almost impossible to regulate it anymore. And that's the question behind. That's also because he referred to the case of the Commission on Antitrust against Google, where we can see that even the most powerful institutions struggle to still regulate this company and its effect. So it's not. I don't think it's paranoid to agree with this view, and I don't think it's paranoid to see that this might have a huge threat. Or might bring a huge threat to democracy even, because we vote for rules and obviously they are not applied anymore because we cannot enforce it against such a global player. But I also have to say that this is not a new debate. If you think about the 90s and end of the 90s and the question, how do we deal with global companies or groups of undertakings in a global market, and how do we deal with democratic legitimacy of G8 decisions taking place, or WTO, and now it's the TTIP negotiations where you can question in how far we can have an impact as citizens and consumers on these regulatory regimes with our own interests. And I think that there is a point where I think that those people like this Mr. Döpfner from Axel Springer, they could have an impact on behalf of citizens and consumers by calling, for example, on their own politicians to be active on creating, for example, a European digital rights bill, a European framework for protecting consumer rights, citizens' rights on the digital market without cutting the cables or without fragmenting the market, but just saying that the rules which we decide here on balancing out the interests of consumers and the interests of business, or the interests of citizens and the interests of authorities, should be applied in the same way everywhere in Europe. And we shouldn't agree on that being undermined by global players or third states which we don't control. So that's behind this debate. But that's, of course, a huge debate, and I think it's very important that we take it.
Hi, I'm Cillian O'Moran. Good to see you. I'd like to ask you about the Irish context and Dublin as a sort of a European tech capital. And given that jurisdiction is usually determined about where a company is located, that what or how can Ireland be a bit of a leader on this issue, but also because most of the internet is conducted in English, or commonly is the language of business, and we trade in the euro, and we're well positioned, that what our role might be.
I think that's a great question, because my impression is that Ireland could play a very important role in the European Union, and especially also Dublin as a tech city is a hub for that development, by insisting on that approach of creating a level playing field for the European Union, for the European digital market, to say that we need common rules to be easily interpreted and where people can get both out of it, legal certainty for everybody who acts on that market, but also trust in these rules to be applied and enforced consistently. And there I think that already some people had tried to get Ireland playing that role. And my impression is that it's on a first good way, that there is, for example, a change away from just the stand which, for example, sometimes the UK takes, like we just profit from our situation, for example, as financial capital city of London. we don't need common rules on that as long we are profiting from it. I don't think that's very sustainable, and I don't think it's creating trust in the system, and that leads to the situation that, for example, there's now a move out of the city on financial issues, and that might happen might have happened if Ireland would have taken the same approach. But obviously, there's a change in perception to that, and in Ireland, people think we are the leading game player on the European market. We are the leading standard setter on the European market. So let's create the European digital market, and that's what I expect from Irish leaders. And I think there's much potential which have to be still used. So there could be even a leading role on European level. And that would be necessary because, as I said, there are other member states which still not realize that we have a single market and that we need a single market and a strong single market, digital market. And that is with regard to the data protection regulation, the whole debate on the one-stop shop, for example. So the competent authority which is competent for the enforcement of data protection. We as Parliament have found a very good solution for that by saying it should be, of course, the main establishments authority which is competent for the enforcement. So, for example, with Facebook, it's here Ireland. But there should be a consistent enforcement. There should be one single law, and that should be applied by all the authorities in a consistent way. So if the Irish authority is not enforcing it in a way like all the other authorities are wanting it to be enforced, then there should be a way how they deal with it together. They should be coordinating or even voting on it. So I think that is a possibility to work on, and of course there should be a possibility for all citizens to go to their own authority. It should be not anymore the case that Max Schrems need to travel from Austria to Dublin to talk with the Irish Commissioner on the Facebook cases. Should be possible for him to go to the Austrian DPA and they talk to each other. That was the more technical part, but I think you were interested in that, so I think that's more or less the proposal by the Parliament, which we hope that member states will go ahead with it now.
Can I ask you a question, if I can take the chance, Jan, because I know you were in Washington a few weeks ago and around the States, and I don't know if you got a chance there to get a really clear picture as to what the response can be in relation to Snowden's revelations in terms of the widespread surveillance of citizens in America and here. What would you see the best outcome development where we would get certain certainty that we're not subject to surveillance? How do you think that might progress?
It's quite interesting because I have been to Washington in October when we were in the midst of the whole debates on how to react on the Snowden revelations. And at that week when I was there, it was the moment where on the one side it was revealed that Angela Merkel's phone was tapped. So in the US people realized that extent, although that's not the real extent, but that's of course the picture, is taking place. And it was the same week where the so-called Freedom Act was proposed in the Congress. So there were Congress people going very far on also ending blanket retention in the US, at least for the intelligence community. And at that time, we were sitting together with White House officials, and they asked us, parliamentarians from Brussels, please tell us what we need to do now, because we are really struggling to find a solution for that. And I think that what we told them had some effect on the outcome of, for example, the White House working group and the reaction of Obama to all this. So they realized that they needed to do something. But not the reaction, the very, I would say, still too weak reaction by the White House and the Congress, although it's more than EU government showed, but not this reaction was important, but the development of the public debate was important. When we came back now, or when I came back now some weeks ago to Washington, it was a complete different sphere. People were aware that this is a topic we need to debate in all Congress committees, everywhere. 2 weeks before, I was also in Silicon Valley talking with companies there, and they realized they need to act. They need to do something because we all as society learned this new step of transition into the digital society, transition into a society in which things are running different and in which we need perhaps some new or other different rules and proposals and also perhaps technical developments in favor of privacy, for example. And that's happening now. So I'm very optimistic about that because that's completely different to what I have learned the 3 years before, where people were coming to me, forget about privacy being a competitive advantage or whatever. I think that completely changed now. And I'm very hopeful that this is now taken up by politicians also, which also have to learn about this new situation. And my impression is that the upcoming European Parliament will be I don't want to exaggerate, but I think it will be the most important place for debates on creating digital rights as on the legislation base. So if you really think about setting legislative standards to protect digital rights, to develop digital standards for the digital market, it will be the European Union's role to play a role at the upfront, and Ireland, as I said, as the driver for that. So I think that could have a huge impact on the development, and it will be the upcoming years. So I'm very optimistic with regard to that.
Mm-hmm. Yeah, Darrell O'Brien from Castlebridge Associates. We've spoken about the role of the European Parliament, we've spoken about the role of European industrialists, we've spoken about the role of citizens. What about the role of national ministers and senior civil servants in taking the principles and actually putting them into practice so they become a living part of how we function as a democracy? What's your thought on that?
Yeah, I mean, that's also a very fundamental issue, because it's not only dealing with the issues which I am talking about, it's dealing with our European democracy in general, because my experience throughout the last 5 years was more and more that the system which we have today, with the Council of Ministers being a very decisive part in European politics, is a bit of an anachronism due to the importance of European legislative decision-making process, because if we are really honest to ourselves, we don't elect our ministers. I mean, we don't elect them anyway, but we elect our parliaments. We don't elect our governments to be accountable for EU legislation. Until now, that doesn't really count so much. At least we don't ask our ministers day by day, hey, what have you done in Luxembourg or Brussels when you went to the council meeting, and which argument did you use, and so on. So it's a problematic situation, and at the moment I'm still optimistic that we might be able to change that we might be able to get the ministers better into account to what they do on EU legislation. But at a certain point, it might be also the situation that we have to say perhaps this system doesn't work, and we need something like a Senate where we vote people to be in a second chamber and be accountable for that. But that's something which is for the next convention, and I don't want to elaborate on that too deep. But what I think is that, for example, with regard to the data protection reform, it's really important that people realize if they want to change something in today's environment, especially when it's about digital rights, they need to get their governments going on EU initiatives. They need to get them going on international negotiations with an idea of what they want to achieve. And that means public debates on these issues. That means perhaps creating even really pressure on governments doing something on behalf of our interests as consumers and citizens. And that's what needs to be developed for the upcoming years. It will be very important.
Thank you.
Hi, my name is Peter Brennan. I'm a computer programmer.
Hi.
Hi. I was just wondering, you talked there about data retention, but what about public data that's out there? What is the difference between me and looking up your Facebook page and me storing that information? I see no difference. All I can see is that if you use a computer, you can apply more sophisticated techniques, and you can process more information. And the second point I want to make, just in terms of analytics for, say, policing or for money laundering or for fraud investigation, this is not a new tech. This is going back a long time. Like, you know, in your own country of Horst Teller, who stopped the Baader Meinhof, they used analytics, and they would use what would be considered very, very crude techniques now. But instead of beating up on people for their political beliefs, because they were union leaders or left wing, or they belonged to a minority ethnic group, they didn't. They could target who they wanted to investigate. I think that's very, very important to remember. That I don't think anybody, police or people investigating these type of things, they don't want to beat up on anybody. They want to get to people perpetrating the crimes. Really, that's it.
Sure. I'm very happy for these questions. I would say on the first issue, still just in legal terms, it's a difference if you just visualize, if you just see yourself information and you just save it in your head, more or less, you know, or if you take it and process it electronically. Legally, that's the difference, you know. So that might be a bit very technically now, but it's the case. If you just write it down, for example, also there, it's not data protection which applies. Data protection legally applies to electronic electronic data processing. But anyway, it's not important. The important difference is that if we talk about data protection, normally it should apply everywhere, because it's somehow like with traffic rules, you know. It's no difference if I'm a private person walking across the red light, or if I'm a company or an authority walking the red light. I mean, if I have a special permit for it, okay, but normally there's no difference. So everybody should respect that red light, you know. And that's the idea of data protection. It's basic rules on how we live together in the information society. Data protection was developed as a reaction to the development of the information society. That's a revolutionary process, and with that process, data protection became a very inherent part of our values. Like traffic rules became an inherent part only when there were cars on the streets. Before, we didn't really talk about that because nobody was afraid to be run over, you know. I think that's very important. Nonetheless, there is a lack of enforcement, for example. If you just walk a red light, you know, it happens all the time. I would say that's the same if you talk about quite a lot of data processing taking place. But generally, it should apply, and generally, in most of the cases, it should be enforced also. With data protection, there's an exception, for example. There is an exception from the red light, which means that if you're doing it in a private environment, in a household environment, then you're not bound to these rules. And that, of course, is something which always needed to be interpreted, what is private and household processing, but that's the case. So that's more or less the answer to it. Generally, I just think it's a basic rule, and it should apply, and everybody should more or less respect it. You know, if I put your data in my private contact book, for example, at a certain moment, perhaps I should ask you if you still want to be in. Could make sense at the end. On the second question, law enforcement. I mean, I would say that without blanket data retention or without this Rasterfahndung, I only know the German word for it, this data mining more or less, law enforcement is not possible. I wouldn't say that. I would say that law enforcement has been done for decades and hundreds of years, and it was possible on suspicions, on what people really realize to see. But I think that there we are very much together, because the only difference here in finding the red line, what should be allowed and what should be not allowed for policemen, is that we shouldn't exceed the reasonable work of a police officer. Why should a police officer in a non-digitalized environment run around and collect personal data from everybody all the time, only just in case he needs that? First of all, that would be spending time on things which are not at all important and necessary to secure the environment, instead of doing effective law enforcement. And secondly, it would be vastly unproportionate, because it's not really appropriate to watch everybody all the time. And that's what we talk about proportionality in the way how we deal with each other. And as a German, I can say that this notion of proportionality is quite an important one, because there could be quite unproportionate behavior by law enforcement authority, legalized, whatever, written down in law, which might change the society away from a free society in which you are able to behave like you want to behave and nobody wants you something bad, into a society in which behaving different might have very severe consequences, because people don't like your behavior and have the power to deal with you in certain ways. So there is a significant importance for that thin red line, proportionality.
But data, yes, exactly, can stop that happening, because like I said, the example of Horst Heller, they didn't target everybody. They targeted very, very specific people.
Yeah, but then it's good. If it's
exactly.
That was made on risk, and that is what the court, by the way, didn't say is not possible. For example, if I know there is a public place somewhere here in Dublin, and we know there's drug trafficking taking place, or there's whatever is taking place on that place, you can have a proportional decision to say, okay, for the upcoming 6 months we'll do video surveillance on it, and if just in case things are happening, because we know things are happening, and after these 6 months, if we realize, okay, nothing happened anymore, okay, we don't do it anymore, So that's risk-focused surveillance with a reason behind it. But we don't do video surveillance everywhere on every street, on every cross, only because it could occur at a certain moment that there's also a crime happening. That's proportionality, Yeah.
One last question, if I can, because I'm very conscious. I'll take two over here maybe together, and that way we could ask for Jan-Philippe to sum up.
Hi, my name is Vincent Costello. I'm from an Irish ISP. My question is two small parts. One, do you see any direction from Europe in relation to the limbo now that the directive is declared invalid? And is there any kind of an understanding of where that's going from Europe, leaving aside the Irish case? And then in relation to the General Data Protection Regulation that's coming on, do you anticipate any developments in the near future in relation to the lobby, etc.? How is that developing, I suppose?
Do you mind if I take two together, Jan-Philippe?
Yeah, sure.
Yeah, mine follows a similar line with the regulation that's just coming through at the moment. That's one step. in a European context with regards to data protection. In terms of kind of harmonizing cooperation across Europe, what do you think are the main challenges for the various DPAs across the region? And in addition, do you find that in Brussels or in other areas that there's much political will to jump on technologies because they're kind of branded, say, as a solution, such as things like biometrics, which are very problematic, but seem to offer silver bullets? And can, do you find that there's a kind of much jumping on bandwagons with those type of technologies?
Mm-hmm. So on the data retention case and the development now, I said I think almost everything from the beginning, but I think that this is really a turn in the debate, and I think it's not a turn in the debate which says we need more data protection than more law enforcement. I don't see that. I don't think that. It's more or less a turn in the debate by saying, let's focus back on the means what we have had in the situation before, where there were abilities to do effective law enforcement also in other ways. And I think that this debate will take place now in all the member states, and it will not be only in Ireland. You see that this case was brought by Digital Rights Ireland, and also but by a mass court suit in Austria. They also have to deal with it. I think it was Slovakia, where now it will go to court. Also, there will be political debates like in Germany, where we never implemented, or once, but not implemented again this directive. So these debates are taking place, but my impression is that times have changed, and after 10 years of debate on blanket retention, we perhaps debate options for law enforcement without blanket retention, perhaps with risk and suspicion-orientated retention and data mining. By the way, data mining is also possible in a restricted environment. It doesn't have to be data mining every time and on all the global world. It doesn't mean that always you need to mine the whole university to get whole universal. No, what? Universe. That was not the whole university. Universe. Okay. On the data protection regulation, the European Parliament has voted almost unanimously on its position, which means really something. So this law will be in place. The only question is when. So will the ministers still prolong it and prolong it with every day it will take? I think we have a weaker position as European Union in the world. And how? And there it will be a good question. For example, will we have a wide scope, or will some member states bring through that their most favorite topic will be exempted at the end, and then we have again 28 different national rules on churches, on lawyers, on whatever. I don't know. So I think that these debates will go on perhaps until the end of this year, and then we'll see hopefully a negotiation between Parliament and Council and an adoption next year. And so we will perhaps have these unified European rules from 2017 if it goes good. But still we need some pressure for that. And then in parallel we will have very important developments going on with regards to other reform processes, net neutrality, data protection, privacy, and other terms. So I think that there will be important developments. And now I forgot the last question.
It was to do with emerging technologies.
Right, exactly. So there I think that for sure this situation where many things are unregulated and unsolved because we don't really walk forward, we don't really find rules because we always think we never can regulate because everything is evolving and everything is global. I think that because of that we will see that the trial and error development will go on. and people will wonder about where some things will go. I mean, I think that on these issues we will see that massive developments will take place without a huge amount of citizens being okay with it. But that's why I think that we need to take decisions and rules now on what we now know, because with fast technological development, there is no alternative than fast repealing regulation. Although that might be very energy consuming and that might be also sometimes very confusing, I think that repealing rules from time to time because of technical development is nothing bad. I would even say it's something good. And that's what I think has to take place. So we need to take some new steps, reforming our rules, finding principle-orientated rules, technically neutral rules, but at the end we also have to get into some very detailed debates on how to use, for example, DNA data, which is also very, it's detailed but not technical. It's a value decision also at the end.
Okay, on that point maybe, and value decisions around technology, I could draw you to close, Jan-Philippe, and I suppose also maybe reflecting just where we are. We're in TCube, which is a Dublin social networking space for technology people to come together and kind of talk in an informal way, to work in an informal way. We're halfway, I suppose, between the digital hub, which was an area here in Dublin 8 that we set up as trying to develop as a technology area, and the Silicon Docks, we're calling it now, slightly pretentious word, but the area where a lot of the large new international companies have based their European headquarters. We're also, I'm just looking out the window, we're right looking at Dublin Castle, which was the heart of governance in our state for a long time. Strange form of governance, wasn't necessarily our own, but it's an interesting space that we're in. And I think what I really took from what you were saying, many things what you were saying here, but I think one of the really interesting things for this city and this country is how we need to get the regulations of this internet right in this city, and even just to understand them so that we get it right in terms of the development of our city, because this city is a technology hub for Europe now. It has some 50,000 people working in small tech companies, huge amounts of startups, huge amount of innovation. The sort of app this has been video on, which allows people to comment on your speech, is not untypical with what's happening in this city, is an amazing level of creativity and enterprise and a good culture that is developing. We need to get the culture right. We need to get the values right if that's to continue more than anything else. And I think this technology, or this data protection, copyright, whole range of different issues around the regulation of the internet is really complex, is hard to understand. It's hard, my experience, for politicians to understand, whatever about the general public. But if we don't understand it, if we don't actually become really good at it, if we don't have the right values informing our decisions, then we will get it wrong. Then we will miss the opportunity, because I think what you said is correct, that getting fair and correct rules in place is not anti-business. It actually helps centering the regulations around the citizen and community, not around business and not around government interests, in the long run is going to be better for this city and this country, or in any other country, because then people trust the trading, then people trust the sharing of information, then it can go into the next phase, which is the environmental solutions it will provide, the educational services it will provide, the health service it will provide, and so on. But if we don't get the values, if we don't get the principles right behind it, we will not get public confidence and trust to be able to make that step. So what I'm inspired by the work you're doing and the leadership you've shown is I think you get it just about better than anyone else. And you get it in a way that you share it. You shared it with those 621 other members of the European Parliament who signed yes. Only 10 said no. There are very few instances in Parliament where you get a vote 620 to 1 to 10. And I think you deserve great credit for that work. I hope that you're back in the Parliament next year, finishing off that work, getting it through the camp, embarrassing the Council of Ministers.
Therefore, I need you with me.
Well, I hope that happens. And I said, I really appreciate you coming to Dublin. I hope it's not the last time. I hope that this city does develop as one of the tech centres and capitals of Europe and the world. And I hope we can count you and we can keep you as a friend as that happens. Thank you.
Thank you.
We're welcome, Barry. I suppose the nature of this place is that you don't walk out the door straight away and that